Good evening, friends. Welcome to my YouTube channel, Advocate Amit Kumar Gupta. In my series on the income tax cases, the case which I am going to discuss today is a very important case. The name of the case is Mrs. NOORJAHAN versus Deputy Commissioner of Income Tax, and this case has been reported in 445 ITR at page number 17. The matter has been decided by Madras High Court, and this case has been decided on 26th April 2022. In this case, the assessee filed its return of income and determined its tax liability. The fault of the assessee was that it was not able to deposit the tax at the time of the filing the return of income. But the assessee suo motu deposited the complete tax and interest thereon after 4.5 months. After depositing the tax, after 1 year, near about 1 year, the department initiated the prosecution proceedings against the assessee. The assessee was before the court for questioning the prosecution proceedings by saying that prosecution under section 276C, which is for willful attempt to evade the tax, cannot be applied in the case of the assessee. Earlier, in the prosecution cases, the department has to prove the culpable mental state on the part of the assessee, that there is culpable mental state, only then the prosecution can be launched. But when section 278E was introduced, through which it was said, it was deemed that there is culpable mental state on the part of the assessee, and the assessee has to rebut that. The plea of the assessee was that when I have determined my tax liability and have filed my return of income, and suo motu before the initiation of the prosecution proceedings, I have come forward and deposited the tax with interest, then how it can be presumed that I have a culpable mental state for the evasion of the tax? The evasion of the tax can be said that when the department has to rush to the assessee and force him to deposit the tax, that this is your tax liability, you are not depositing the tax. But when the assessee is determining its tax liability and filing the return of income, then at this stage itself, it cannot be said that there is culpable mental state on the part of the assessee for the evasion of the tax to make him entitled to initiate prosecution proceedings against him under section 276C. And in any case, in this particular case, section 278E cannot be applied because it cannot be presumed that there was culpable mental state. So this was a flat case for the assessee, and the assessee has not to prove much by more than depositing the interest and tax after 4.5 months before initiating the prosecution proceedings. So the assessee has a very favorable case in this particular matter, because there was no action by the department for making the assessee for the payment of the tax or for filing the return of the income. When the assessee himself is coming forward and fulfilling all its responsibilities as a citizen of India, and the department has not to make the efforts or extraordinary administrative actions to take the tax from the assessee, then it cannot be said that there is a willful attempt on the part of the assessee for the evasion of the tax. So in this particular case, the Madras High Court said that this is a perfect example of the abuse of power by the officers of the department. It is a perfect example of the non-application of mind. So this type of practice should be adopted, should be avoided by the department, because it demoralizes the assessee to follow the fiscal laws and to deposit the tax on time, because there is a journal saying that the tax should be collected from the assessee in a manner like a bee sucks the nectar from the flowers. But it should not be, an atmosphere should not be made where an impression goes into the society that there is a tax terrorism in the country or something like that. So In this case, the Madras High Court made a very remarkable judgment by saying that it is a case of abuse of power and the department does not have the power to initiate the prosecution proceedings in this type of cases. Friends, at the end of this video, I am once again repeating the name of the case. The name of the case is Mrs. NOORJAHAN versus Deputy Commissioner of Income Tax, and this case has been decided on 26th April 2022, and the matter has been reported in 445 ITR at page number 17. Thank you, friends.